Prepare well, and I was with the air conditioning man who wants $2,000 from me. I thought maybe that's the job I need. That guy makes pretty good money. Congratulations to all of you for being here, and thank you for the job you do. I became a lawyer, and the first time I ever thought of becoming a lawyer was my high school civics teacher's husband was a lawyer, and no one in my family had ever gone to college. I didn't know any lawyers, and I remember my high school teacher's husband. She dragged him into our class, and so we had a real lawyer come to our class and talk to us about law and all. And then I went home and told my mother that this lawyer had been in our classroom and talked to us, and she told me that lawyer had been her paper boy when she was growing up. So that's when I first got the idea, well, if this paper boy for my mother could become a lawyer, maybe I can become a lawyer. Then I wasn't very good at being a lawyer, so they made me a judge. That's what happened. Thought I'd talk to you about federal courts. Feel free to ask questions of any type, because it's really hard with an audience of this type, because many of us are used to talking to lawyers about more sophisticated legal issues, and you're not quite there, but you're pretty sophisticated about the law too. So if I'm too elementary, tell me to move it up, and if I'm too complicated, tell me to move it down. You can do that. The lawyers can't. They just have to sit there and listen and then tell me how great I am, because they love to suck up to judges. But you feel free to interrupt me at any time. This is our fancy building in Washington. It's right next to the train station. If you're ever up there, I have some handouts that I just brought with me this morning. But we're very involved in part of it in teaching and being involved with students. And there's a email address there, and there's a lady named Rebecca Fanning that you can contact, and she's in charge of all these programs that we put on, and she can give you all sorts of ideas. Just email her, call her, or if you're up there, she'll set up something for you. But by all means, we do have all sorts of resources that are available that a lot of people don't know about, and the frustration for the courts is sometimes we can't get that information to you guys to let you know we're there to help you out. I would also encourage you to contact your local courts. There are some nice judges. A lot of us aren't nice, but there are some nice judges. We have been, I don't know if this is constitutional or not, but we have been for the last, 18, 19 years. We're close to some public housing, the courthouse, and we invite all the kids in the public housing to come to the courthouse on a Saturday, and we do a take off on Miracle on 34th Street, and we put Santa Claus on trial. He goes to the local elementary school on Thursday to give out candy, and the principal has him arrested because strangers aren't supposed to get on campus and give out gifts. So the kids are told Santa's arrested. He's going to be on trial at 10 o'clock Saturday morning at that building two blocks down, so all the kids are invited to come over. Now we get a Santa Claus from the local department store. The principal's the bad person. She testifies. We have Boy Scouts and Girl Scouts working on their merit badge to work with law students, and they're the lawyers, so we have Boy Scouts and Girl Scouts competing with each other as the lawyers. And we have a lot of fun, and then we have cookies and punch and show the kids to the courthouse, because a lot of them, even though they're right, it's in their neighborhood, many of them have not been into a courthouse before. So we open it up on a Saturday, we have this thing, and we make it short because attention span, as you know, for these kids sometimes is tough. So we do it in about an hour and a half, and they have a lot of fun. The fifth graders are our jury, and so we have the fifth graders, and they always find Santa Claus not guilty. And I think it might be because I remind them that if they find him guilty, I'm going to put him in jail. He won't be around on the 25th, and there might not be any gifts. So they always find him not guilty. The other thing we do is put Goldilocks on trial for breaking and entering into the Three Bears house. And that's a lot of fun, because we have all the fairy tale characters. And we have Peter Rabbit and Little Red Riding Hood and the Big Bad Wolf, and all these people come to testify. Goldilocks is found guilty most of the time. And then we also open it up for the high school students when they're doing their mock trial competitions and they're preparing and all that. We will usually, if we have a free courtroom in the afternoons or something, let them come over and get a feel for doing it in an actual courtroom, and we'll have some lawyers that are working with them and critique them and tell them that. So don't be timid about contacting your local judges and seeing if they will open up that courthouse. I tell people that my courtroom is not mine. It's the people's courtroom. It's the public's courtroom. I'm borrowing it to do my job, but it's really a public building for the public. So you should be able to use it. So don't be intimidated. If you have a little problem with your judge, give me a call. I'll call that judge and talk to him. When you're an appellate judge, sometimes you have a little clout with the lower judges. So let me know. But I do encourage you to get the students involved in going to the courthouses and doing things of this nature, because the kids learn so much just seeing what's going on. And it's entertainment, but it's also educational for the kids. Let's see what I have. Federal courts are kind of boring sometimes. People think we got a lot of these federal administrative stuff that is not more exciting. We have less than 10% of the cases come to us. We don't get all the juicy, gossipy stuff that goes on, all the murders and rapes and assaults and all that stuff, car accidents, divorces, all that stuff doesn't come to us. It has to be something involving the Constitution or a statute passed by Congress. We are a court of limited jurisdiction. The first question that we ask is, can I hear this case? And there has to be some statute or some constitutional issue. Otherwise, it goes to state court. And the more cases I can send to state court, the less work I have. So the first question I ask is, can I hear this case? The states have their cases, but they have they take up everything else. They have 90% of all the cases or more. So that's where we're at. But constitutional issues can be real juicy. Are any of you familiar with, I think it's Morgan versus Swanson case from the Plano School District? It is pending right now before my court, and it is a very close case, and you should be very interested in that case.
The candy cane?
Yep, the candy cane case. You are, some of you are familiar with the candy cane case. Yeah. There are several versions of it. There are actually 4 or 5 different situations. A little girl in elementary school, but has pencils that say, Jesus loves you, I think. And she's giving.
Jesus is the reason for the season?
Yeah, that's the other pencil. That's the candy cane pencil. There are different versions. There are actually 5, but she's giving out pencils. The principal and the teacher says, you can't give them out here in school. This is a religious thing, and you're doing it, and it wasn't interrupting school. I think it was during cafeteria break. And she's giving out pencils with a religious message. Another situation is a candy cane pencil, and it said Jesus is the reason for the season. There was another situation where they were giving, a student was offering free tickets to the Passion Play during Easter for friends. And these weren't taking place in the classroom, but they were between classes in the cafeteria. In one situation, the little girl was having a birthday party at the cafeteria during the lunch hour, and her mother gave her a bunch of pencils to give out to her friends. In all these situations, the principal said, no, we can't have this. The separation of church and state. We don't want it to look like the school is promoting a particular religion. So they took away the pencils, or they stopped it. Well, the parents sued the principal, and the principal is now being sued for doing this, saying that it violated the child's First Amendment right, freedom of speech, freedom of religion. So you have these conflicting constitutional issues between First Amendment freedom of speech and the issue of church and state and the school appearing that it is promoting certain religion. And it's rough on you guys because we judges have screwed up the law. And there are all these cases out there that sort of tell you different things. If you're the principal or the teacher, it's like, what do you do here? You know, if you allow it and say, yeah, go ahead, give it out, next thing you know is you're going to get in trouble because it looks like you're promoting a certain, or the school district is promoting a certain religion. If you don't allow it, you're going to be sued like these principals in the Plano School District. And I'll tell you, it's a case that's taken en banc, which means all our court is meeting. There's 17 of us. And we can't agree. And you have 17 judges who have all this experience and supposedly bright people that know the law. We are having a very hard time on this case determining whether the principal is immune from a lawsuit because he was acting in good faith, or whether he violated this student's constitutional rights. So be careful. And I wish I could give you some guidance, but we can't even decide among ourselves. Yes, ma'am.
I know you said it was in your court, so I know you really can't talk a whole about your opinion on it. But I did have a fellow teacher just last year that wears a very small crucifix sometimes, who told me I wasn't allowed to wear that because it's promoting religion. And I basically told him he could get off. But I know I'm allowed to. And so, I mean, has the courts at any point said teachers could not wear religious jewelry? I say they have it, but I can't prove that.
Terry, I don't know of any case on point. Do you? I don't know. I mean, there's so many. We have to wait till the specific facts get to us. So there's no, until a case gets to us like that, there's nothing out there. You sort of have to look at the old, this is what's challenging. You look at the old cases and say, okay, now if you follow through with this, where does this lead us? And that's where we get into the argument, because we have all these cases about, yes, you can do this, and no, you can't do this, and then you get this set of facts, and okay, now where does this fit in with all these old cases? And that's where we have a challenging thing, and it's really, the dynamics of being on the appellate court are really interesting, because, as I said, we're 17 judges. I'm already getting off track, but since we can't agree, and you have 17 judges from different backgrounds, that's where you have it, is that we all have different backgrounds. Some came from affluent backgrounds, some came from poorer backgrounds, some went to private school, some went to public school, you know, some went to Harvard, and others went to a night school. And so we come with our personal experiences and our different educational and life, and so that affects how we interpret the law, I think. You know, and you think, okay, the law should be set straight, but in our country, they're just general laws, and it's up to us judges to interpret those laws. And we wish we could be black and white, but it's not that way. And we can look at a case, and one judge can say it means this, and another judge can mean it says this. And it's not that one is wrong. It's just it is a gray area, and that's the challenge of our job that makes our job pretty hard. I would say 9 out of 10 cases, it's pretty obvious what the law is. I mean, most of it, it's clear. This is it. But you got that 10% that could go either way, and that's where our job is challenging. And that's where I'm grateful that my job's a lifetime appointment, and you can't vote me out of office. Yeah. Yes, sir.
Do you decide a case by simple majority, or is it 3/4, or what do you have to do to decide a case?
Yeah. On the appellate court, we sit in groups of 3. Okay, so it's tried in your local district court, wherever you're at. Then it gets appealed to us, and we're 17 judges, and every month we rotate and sit with different ones. So there are 3 judges that sit, and the 3 judges sit, and we review that particular case, and we vote. And most of the time it's easy case, 3 of us agree. Occasionally it's 2 to 1. If the rest of the judges see that opinion from that 3-judge panel, and they see that one judge dissented, they're gonna look at, the other judges are gonna look at it carefully and think, well, maybe that one judge is right and the other two are wrong. So that's when we go what is called en banc, which means the whole court then reviews that particular case. So it's sort of an intermediate appeal between going from our court to the Supreme Court. So first you have the 3 judges review it, then you can have the whole court. I say 17, that's the 5th Circuit where I'm at. We cover Louisiana, Mississippi, and we have Texas. And I always say Texas has common law, and Louisiana has civil law, and Mississippi has no law. And I have to interpret the law for those states. But depending on the circuit you're in, like in the 9th Circuit that covers California and the whole West Coast, it is an extremely large circuit, and they have, I think, 28 judges. We have 17. There are other courts that only have 6. So depending on the size of your circuit, your region, the size of the court can vary. So if you have a majority of the 17 judges that say, we think that 3-judge panel got it wrong, then we set aside that opinion and we hear it en banc. And that's what we're doing on this case involving the pencils, the candy cane pencils, is a 3-judge panel ruled that the lawsuit against the principal could go forward. And that maybe it hadn't gotten yet to the actual trial because the principal said, this case should be dismissed. I was just doing my job. I thought that this little girl was bringing religion into the school and that couldn't happen, so I did my job as a principal, so this case should be dismissed. 3 judges on our court said, not so fast. Maybe this little girl has a First Amendment right, freedom of religion. It was not interrupting classrooms. So maybe you overstepped your boundaries, principal. So we're going to let this lawsuit go forward and see what happens. The majority of the court, the 17, the rest of us, go, whoa, we're not so sure. We think maybe this principal shouldn't be sued and maybe this case should be dismissed. So that's where we're at right now. And it's a close call.
Is the petitioner asking for damages, monetary damages for
Yeah.
the principal?
Yeah.
Okay.
And the schools have so much money anyway, don't they?
It's
I mean,
in.
personally and from the school, yeah, but from the principal personally and then from the school. Or, psychological damage, all these things that, people bring up. But yeah, they're sued for money damages.
It seems to me that the ultimate ruling, whether it be in the circuit level in Washington, would come down to separating the damages issue from the civil liberties issue of the exercise of religion, or they're trying to restrict it.
Yeah, you'll get into another issue because what are damages? I mean, that's where a jury gets in and, some lawyer's going to say, this poor little girl is, psychologically scarred for the rest of her life. My God, she'll never recover from this embarrassment and she needs psychological treatment and it's going to affect her grades for the rest of her life, and she was going to be a PhD and now she's probably going to drop out, so she needs $2 million, or $5 million. And then the lawyer for the school district says, look, it was a small little thing, the little girl probably don't even remember it, token $1, $2 thing. The issue is not the money. I mean, it is if you're the principal, but I mean, the issue is how far can religion come into the school? But yeah, they're seeking money damages.
I was born and raised in Florida, and I finished high school and college in Mississippi. So I know that they're making up laws as they go along. But my question is, even though the responsibility, the decision was made on the principal, would there be some leverage as it relates to where the school district would play in covering the principal with the decision that was made? Would the school district be brought in, or is the principal having to deal with the ramifications?
Well, that's the other issue is was he acting under the guidance of the school board or the superintendent? Was he following regulations, or did he go outside the realm of what he's supposed to be doing? So that's another issue that would come up is, was he just following the rules that have been dictated down from the superintendent or the board, or did he act on his own? So that's going to be, if that case ends up going to trial, that's going to be another issue is, who's responsible, him or the school board or the superintendent.
Sir, if you're going to, now that you're en banc for this particular decision, do you go back and hear arguments, or do you just review the transcripts?
No.
And what is your timeline? When do you expect the decision to come down, and might this?
We go and close the door and we flip a coin. No. This is an interesting, I don't think you can get it,
Rock, paper,
but
scissors.
I can get it. But we had arguments about 2 months ago. Okay? And we heard it. And it's intimidating. If you're ever in New Orleans, by the way, if you do go to New Orleans, let me know and I'll set you up for a tour of the courthouse and you'll see. But you can imagine you're a lawyer there, and I don't know if Mr. Goldstein, have you ever argued en banc?
Yes, and by the way,